Subcontracting in public procurement plays an important role, as most companies in the internal market are small and medium enterprises. Access to public contracts often will be available for them through opportunities to become a subcontractor or to use others SMEs to help them out to accumulate enough capacity to bid for the contract. Therefore, subcontracting has a strong social dimension to public procurement, instrumentalization as it might contribute to creating new jobs. Subcontracting is often used to supplement the personal, economic, or technical resources or increase bidders' capacities. While subcontracting has an important practical function, its regulation has been scarce under procurement law. The directive does not include a provision that would expressly allow subcontracting or set up a specific requirements for direct execution of the contract by the main contractor who wins the bid. As many other aspects of procurement law, help came from Court of Justice more than 20 years ago. It ruled that bidder cannot be excluded from a procurement solely because they want to use subcontractors in the delivery of public contract. Today, the 2014 directives introduced Article 71 on subcontracting, which deals with three distinct aspects of subcontracting. Information about subcontractors to be provided by bidders or the main contractor to contracting authority, compliance of subcontractors with exclusion criteria and sustainable laws under Article 18.2, and the possibility to arrange for direct payment and liability of subcontractors. The goal of introducing provisions on subcontracting is to provide a greater degree of transparency and oversight of subcontracting and avoidance of those in breach of legal obligations such as labor laws. The involvement of subcontractors, especially multi-layered long subcontracting chains, will limit the transparency of what is going on and potentially impede proper monitoring and oversight of contract performance. Consequently, if there are many layers of subcontracting that also span through several jurisdictions, it is challenging to monitor compliance with human rights, health and safety regulations, or environmental law compliance. To ensure the effectiveness of procurement as an enforcement tool of Article 18.2, it relies on public buyers' ability to monitor supplier compliance and take actions against violations. The task that is particularly difficult if subcontracting entails long, complex chains. Article 71 provides safeguards, such as direct payments, stricter liability rules, transparency obligations in the course of execution of the contract, or the possibility to require the replacement of subcontractors to ensure compliant contract delivery. Where national laws allow for joint liability of contractors and subcontractors for the performance of a contract, the obligation to comply with all sustainable laws from Article 18.2 is to be extended to cover subcontractors. Compliance with these laws is to be ensured by appropriate action of the competent national authorities acting within the scope of their responsibility, but also their remit. Examples of such authorities are given in the recitals, pointing out labor inspections or environmental protection agencies as competent national authorities. However, this must be understood as an additional layer of enforcement to the direct ability of public buyers to enforce joint liability and or require the replacement of the subcontractor in the breach of those relevant obligations. While subcontractors have a strict obligation to comply with Article 18.2, the fact is that their failure in this context ultimately comes at the main contractor's expense. This has been emphasized in the Tim case. The case concerned compatibility with the directive of the Italian legislation. A public buyer should exclude a bidder from participating in a tendering process if the rules on access to work for people with disabilities had not been complied with. An economic operator challenge its exclusion due to a subcontractor's failure to comply with these rules. This case showcased that the bidder's suitability as a contractor can be affected by breaches committed by their subcontractor. As emphasized by Advocates General Campos Sanchez Bordona, a level of due diligence is expected from the tenderers, and an example of an insufficient level of due diligence is shown by a failure by a tenderer to carry out checks when it includes in its tender a subcontractor that has breached obligation in Article 18.2, is at the very least a case of negligent omission. Finally, applying the proportionality principle would determine the limit of the expected due diligence. The Court of Justice confirmed in TIM that attention must be given to proportionality as a general EU law principle, where the exclusion provided for by national legislation is imposed on the economic operator who submitted the tender for a failure to fulfill obligations committed not directly by that operator, but by a person outside his undertaking. In relation to control over whom the operator may not have all the authority required or all the necessary means at his disposal.